Ready, start. An affidavit has been filed by the registrar within bracket I and L bracket close High Court of Madhya Pradesh dated 23/8/2025 stating therein that the matter was placed before the recruitment committee which noted that no ineligible candidate who had been declared successful in the main written examination would be considered and that only those candidates who fulfilled the amended eligibility criteria would be called for interview. Conduct of a third main written examination would result in various difficulties. It is in the aforesaid backdrop that the learned counsel for the parties have been heard. Learned counsel for the appellants at the outset submitted that the High Court committed an error in exercising review jurisdiction and issuing the impugned directions. According to him, when the writ petition filed by the respondents herein was decided on 7/5/2024, the validity of Rule 7 within bracket G of the Rules of 1994 had been upheld. The respondents having not secured the cut-off marks, there was no basis whatsoever for the High Court in exercise of review jurisdiction to reopen the proceedings and direct the appellants to conduct the third main examination by recomputing the cut-off marks. Merely by stating that there was an error apparent on the face of the record for invoking review jurisdiction, the High Court proceeded to reopen the matter and thereafter take a different view, thereby substituting its earlier view. Such exercise was not permissible in exercise of review jurisdiction. In that regard, the learned counsel has placed reliance on the decisions passed in Northern India Caterers versus Governor of Delhi and Kamlesh Verma versus Mayawati. It was then submitted that the impugned exercise undertaken by the High Court was on an incorrect premise that ineligible candidates were likely to be appointed pursuant to the advertisement dated 17/11/2023. It was the specific case of the appellants that no ineligible candidate would be considered for appointment and hence entire basis for the High Court to have undertaken such exercise in review jurisdiction was impermissible. It was also incorrect to state that the earlier cut-off marks would be reduced to enable those candidates who had scored lesser marks than the cut-off marks to be considered for appointment. Merely on the ground that a second main examination was held for physically impaired candidates, same could not be the basis for directing a third main examination to be conducted. The candidates who were successful in the preliminary examination had not been impleaded as parties in the review petition and the impugned direction causing prejudice to them was issued in their absence. Reliance was placed on the decision in Canara Bank versus Devashish Das in this regard. It was also necessary to bear in mind that the advertisement in question sought to fill up vacancies of the year 2022, while the impugned exercise was directed to be undertaken in 2025. It was thus submitted that for the aforesaid reasons, the impugned order dated 13/6/2024 passed by the High Court in exercise of review jurisdiction was liable to be set aside.